I agree with Professor Barnett that the original meaning of the Constitution is not fully determinate. Professor Barnett emphasizes the vagueness of certain words in the Constitution, like unreasonable in the Fourth Amendment. Even if we could all agree on the basic meaning of that word at the rule level, we're still likely to disagree about how to apply it in particular circumstances. Unreasonable is a word with fuzzy borders, and people trying to apply it to particular fact patterns have to pour some content into it, some extra content into it during the process of application. It's also possible for indeterminacies to exist at the rule level. I'd probably go farther than Professor Barnett in that respect. I suspect that the Constitution has quite a few rule-level indeterminacies, including genuine ambiguity rather than simply vagueness. Of course, context will resolve some superficial ambiguities, like whether arms in the Second Amendment refers to weapons or limbs. But even if we can resolve ambiguities in individual words, we'll still face ambiguities about what's implicit in the Constitution. That's a standard interpretive problem. I think it's particularly acute with respect to the Constitution because the Constitution was an unusual sort of document and it wasn't adopted against a completely settled interpretive background. Here's an example of an ambiguity about what's implicit in the Constitution. Does Article 1 of the Constitution give Congress the authority to abrogate state sovereign immunity and expose unconsenting states to suit by individuals? Maybe the necessary and proper clause empowers Congress to expose unconsenting states to suit as a means of carrying into execution other powers that the Constitution vests in the federal government. But founding-era lawyers could plausibly have argued that that wasn't the sort of power that a provision like the necessary and proper clause could convey. As far as I've been able to tell anyway, that's a genuine ambiguity in the Constitution. So my starting premise is that decision makers who have to interpret and apply the Constitution will face some indeterminacies at the rule level, like indeterminacy about the category of powers that the necessary and proper clause does or does not convey, as well as some indeterminacy at the application level, like fact-bound disagreements about what's necessary and proper in a particular setting. At the rule level, decision makers will have to pick a particular formulation from among the permissible readings of the relevant provision. At the application level, they then have to figure out the operative effect of that formulation, the formulation that they've chosen, for the particular set of facts that they're facing. I take Professor Barnett to be using the label construction to cover both of those activities, but I want to focus only on the first sort of construction, the resolution of indeterminacies at the rule level. The question that I want to take up is this: how should modern-day originalists perform that sort of construction? In particular, when they've identified a genuine ambiguity in the original meaning of the Constitution, should they confine themselves to resolving it on the basis of considerations that would have been available to founding-era lawyers and judges, or is it sometimes permissible within the zone of indeterminacy, in what I'm calling the original meaning of the Constitution, for modern-day decision makers to resolve the indeterminacy according to present-day considerations? Just to give a preview of my position, I'm going to claim that principled originalists can take the latter position. In other words, it is permissible within the zone of indeterminacy for present-day decision makers to make choices on the basis of present-day considerations. That's the position that I associate with Keith Whittington, who pioneered the distinction between interpretation and construction in this context, and I agree with that position. To help domesticate the position, I think it helps to consider how we ascribe meaning to statutes. I personally am an originalist with respect to all written laws. I care about the original meaning of both the Constitution and statutes, but it's a fact of life that the typical written law is not fully determinate on every single question of interpretation that decision makers will confront. Every single question of interpretation that lies within the domain of that particular written law. How should courts and other decision makers that have to interpret and apply the written law in particular cases react to that fact of life? With respect to statutes, at least, there's a fairly broad consensus, subject to a few outer limits, which I associate with the non-delegation doctrine. The decision makers, whom we colloquially call interpreters, should go ahead and choose from among the permissible readings. When a statute is intractably ambiguous in some respect, interpreters don't have to conclude that there has been a failure of communication and that the statute has no enforceable meaning at all in that respect. Instead, they can select a meaning to ascribe to the statute from within the range of possibilities that their interpretive techniques have identified. Of course, to the extent that we want different interpreters to settle upon the same meaning, there can be complicated questions about which governmental institution should take the lead in making the necessary selection. For instance, with respect to statutes that Congress has put an agency in charge of administering, and particularly with respect to provisions that Congress has put the agency in charge of administering, the Chevron doctrine often tells courts to accept the meaning chosen by the agency, even if the courts themselves would have made a different selection. But the important point for our purposes is that some interpreter is pouring a little extra content into the relevant statutory provision at the rule level, content that lies within the domain that was marked out by the enacting Congress, but that wasn't fully specified by the enacting Congress. All that can start happening the moment a statute is enacted, but as the statute ages, interpreters have to face a further question. To the extent that the statute is genuinely ambiguous in some respect, should they try to resolve the ambiguity as if nothing has happened since the moment of enactment? Or is it ever okay, within the zone of indeterminacy, for them to rely upon considerations that wouldn't have been available then, such as later developments in the law, or new understandings of economics, or a current consensus about public policy? Don't misunderstand that question. There are many respects in which the way that interpreters would have proceeded at the time of enactment will contribute to the provision's determinate original meaning. Everybody agrees that the meaning of a legal provision emerges not from the provision's words alone, but from the combination of those words and certain types of interpretive principles that form the backdrop for them. To the extent that those background principles of interpretation was enacted, give the statute a single determinate meaning on some point, future interpreters who care about enforcing the statute's original meaning don't have a choice to make. They have only one option. But where the original meaning, as identified by the relevant interpretive principles, is conceitedly ambiguous, and interpreters do have to make a choice among the permissible readings, must they try to make exactly the same choice that they think their predecessors would have made at the time of enactment, or at least to rely only on considerations that would have been available at the time of enactment? Even people who care about identifying and enforcing the original meaning of statutory language have suggested that the answer is no. Take Justice Scalia. In cases of first impression that implicate a genuine ambiguity in the original meaning of statutory language, Justice Scalia seems willing to let courts take account of present-day considerations that would not have been available to prior courts. For instance, to the extent that an old statute is ambiguous, Justice Scalia has said that judges should choose among the permissible readings in such a way as to harmonize the statute with later enacted laws. Here's how he put the point in West Virginia University Hospital against Casey. Where a statutory term presented to us for the first time is ambiguous, we construe it to contain that permissible meaning which fits most logically and comfortably into the body of both previously and subsequently enacted law. Likewise, when a statute could permissibly be understood to establish either of two different directives, and when nothing else compels one choice or the other, Justice Scalia seems willing to let courts base their choice on lessons provided by post-enactment experience, or current knowledge about facts that bear upon which directive will produce better results in practice. That's certainly how we expect agencies to handle ambiguities in the statutes that they administer. Within the range of the statute's indeterminacy, agencies will frequently rely upon current considerations rather than past considerations.